My name is Antonio Martin of the Martin Law Group, and I'm the owner and managing member of the Martin Law Group, where we help reasonable people redefine family. Today, I wanted to share something extremely valuable to you. In our years of practicing in family law, we have come into contact with several individuals who experience some type of domestic violence, but they have not reported it to anyone until the time that they've come to us. And we ask those individuals, well, when you say that this happened a year ago or 6 months ago or 2 years ago, why didn't you report it at that point in time? And we've gotten a plethora of different stories. Sometimes people are afraid. Sometimes people feel like no one's going to listen to them. Sometimes they just think that the behavior is normal and it's just a part of being in a relationship. And so what we're hoping to do with these next set of videos is really provide some practical tips on demystifying the domestic violence process, what constitutes domestic violence, so that you will have an understanding of whether your situation is something that might be domestic violence and how that may be able to benefit you in the future, as well as what that entire process may look like from the beginning to the end. We certainly hope that if this applies to you, that you watch these videos and get some good information from them. Thank you for listening. Now, what you'll notice is that every county is a little bit different in this particular instance. For instance, there are some counties that are going to have forms, and there are going to be some counties that don't have forms for purposes of domestic violence situations. But what we've done is we've taken the liberty of going to the flcourts.org website. You'll see here in the upper left-hand corner, it says FL or Florida Courts Family Law Forms. This is often a location that has a wealth of information related to family law and its forms. Again, take the time to read the different forms so you have a good understanding of which ones that are going to apply to you. Now, you'll see this link here where it says domestic, repeat, sexual, or dating violence, including stalking. That is the place that you want to be able to start your process. And right there, you'll have the forms 12.980, which reference the petition for injunction for protection against domestic violence, including dating violence, repeat violence, sexual violence, and stalking. So these documents are going to be what are necessary to fill out. It has a PDF form that you can print out and fill out on your own, and you can file it in the respective county where you reside. Or you can go to the RTF, which is essentially the Word version, or the web form version of this particular document. So I'm going to click on the web form version so we have an opportunity to look at it. You'll see right from the beginning, there are very extensive instructions on exactly who qualifies to file a petition for injunction for protection against domestic violence. One thing that is important to know here is that when filing these particular documents, the petition itself is for you, the filer. Now, if you are filing on behalf of a child or someone else, you're going to need to file what's called OBO, or on behalf of. So in creating the documents, you need to make sure that there's a distinction between protecting yourself versus protecting your children. That would need to be a separate petition that will need to be filed on their behalf. So if, for instance, just as an example, let's say there's a child that's living in a separate home. You're a non-custodial parent and you have concerns that domestic violence may be taking place in the custodial home. You may have the ability to file a petition, but you have to file it on behalf of the child that is in that particular home in order to attempt to get the court to provide the necessary protection that would be needed. So as you go through this particular item, you'll see that there are, again, similar to many other forms, there are some special notes. And then the special notes, it's going to reference a UCCJEA, which is the residence where the child has been residing for at least 6 months, a potential parenting plan, a notice of social security number, and a family law financial affidavit. Now, I want to go into a little bit of detail about what this process is going to look like. Now, the process isn't going to be explained by the forms themselves, but it's important in order to have a little bit of peace of mind going through this extremely uncomfortable process to know what the process looks like. So the first thing is, once you fill out these papers, you have to then take those documents to the domestic relations department within the particular county. So within the Central Florida, that would be Osceola County Courthouse, Orange County Courthouse, or Polk County Courthouse. Okay, when you file the documents. Now, once you file the documents, they have to be signed and notarized, obviously. And once those are taken care of and submitted to the clerk of court, those then are going to be sent to a judge who's going to make a determination on whether a temporary injunction needs to be filed for this particular matter. So if you're a woman and you are concerned that somebody's going to hurt you physically and you file an injunction, well, the injunction is not granted on a permanent basis right then and there. What will happen is the court will make a determination as to whether the injunction needs to be granted on a temporary basis until the court has an opportunity to set the matter for a hearing. And at the hearing, the court will then make a determination of exactly whether a injunction needs to be granted on a permanent basis or for some periodic term, a year, 2 years, 3 years, what have you. So the allegations within the complaint itself are going to be reviewed by a judge. But that in and of itself does not grant a permanent injunction. There are other steps within that process that are going to require you to go to court, require you to bring whatever witnesses that you may have of whatever you've possibly experienced, so that the judge has the ability to hear both sides.